You raped me. You knew I was highly intoxicated, yet you used that as a selfish opportunity.
Some cops were never told no, and it shows. Especially in court, they walk in confident that the badge will save them, but today, we're exposing the moments when judges shut that arrogance down and roast them on the record.
You use your badge and the authority and power it grants you as a means to implement your criminality.
In 2016, Officer Eric Fritz pulled over Melissa McMillan, who was just trying to get home after a night out. But what happened next? Let's just say the officer's move was absolutely horrible and left everyone shaking their heads.
Yes, my friend Melissa said she's going to get a hold of her friend Joe.
Okay, well, put it this way. You got about less than 5 minutes for her to make that decision. If not, I'm going to end up probably impounding your car and you can go to his house, okay?
Oh my God, please.
Alright?
And she said he's an author.
Did you put your pants on? Where did you put your pants on?
Please tell me right now. Melissa said he was.
I don't know. Do you have a problem with me looking in the car to make sure there's no marijuana so I can smell it? Can I look in your car and make sure there's no marijuana?
Oh my God, you can look in this car. I am a nurse.
Okay.
Nothing.
Can you do me a favor? Stand right about here for me? Where my light is?
Yes.
Can you stand or can you not? You were going to be putting them on a couple minutes ago, so...
No, I had a skirt on.
Where's your skirt at?
I don't know, it's in this car. But I was driving, he was driving, I was driving.
Instead of helping her to get home safely, Officer Fritz did the unthinkable. He took drunk Melissa to a hotel and assaulted her.
What did he say?
Okay. Do me a favor. Come on, stand out here for me, right, Melissa?
Look.
You don't want to kick that shoe. There you go. That'd probably be better. Here, I'll throw your shoe on the floor for you.
Yes.
You can just leave that there. That's fine. Hang on.
Excellent.
Hang on, right there in the front of the car for me, okay?
That's okay.
That's all right. That's no reason for you to be sorry. I heard you.
Hold it for my son.
Come on, Melissa. I need you to hop out.
Yes, sir. Let me get my stuff.
You got everything?
Yes, I'm okay.
Alright.
Go here.
You get it straight around. I need you to come with me, Melissa.
I know you need me to get out of the car right now.
I know you.
I'm going to see you right now. I hope I'm my cigarette. I'm stuck in the room right now.
I'll get you.
I'm sorry, I'm calling you.
That's okay.
It's a volunteer officer.
Being on the side of the road.
You do remember that?
Very, very vaguely, yes.
On one of the beds that was in that room?
Yes.
Okay. And do you remember doing that, or?
The victim says she tried to get up in the middle of the assault. Officer Fritz is finally going to face the consequences of his actions.
Did there come a point in time, or do you have any memory of the officer returning to the hotel room?
No.
Okay. What is your next memory of seeing the officer there in the hotel room, if at all?
The next memory I have is through that top of me.
During sentencing, Melissa took the stand, and her emotional testimony was powerful, revealing the deep trauma she endured.
The police officer who took an oath to protect and serve the community. What you did to me was wrong. You raped me. You knew I was highly intoxicated, yet you used that as a selfish opportunity. My life has been forever changed. Every aspect of my life has been affected. My children have struggled. My friends, family, and loved ones have watched me through a year of hell. I can't see a police vehicle without feeling fear or be reminded of what happened. I made a poor decision to have too many drinks, putting myself in a vulnerable position. I don't remember leaving the bar that night. My friends had arranged for another person to drive my car as I was far too intoxicated. I had no idea the driver was also intoxicated and would get pulled over by a police officer.
Mr. Fritz was also given the chance to speak, and his behavior made it clear that the officer showed no remorse for his actions.
Mr. Fritz, anything you wish to tell me?
Yes, Your Honor. first I'd like to apologize to my friends and family who I've actually lived down. I'd also like to apologize for my coworkers who I embarrassed by my decisions. I'd also like to apologize to the people of Courtroom Township for my actions that night. And I absolutely would like to apologize for Ms. McMillan for my horrific decision of offering her a hotel room. I never should have offered her a hotel room in the first place. It never should have happened. I never should have put her in that situation.
You took a law enforcement oath of honor to protect and to serve and to uphold the highest of ethical standards. Instead, you preyed upon and exploited and damaged a woman who was entirely helpless due to excessive intoxication. Even more disturbing to this court is the fact that you used your badge and the authority and power it grants you as a means to implement your criminality. You betrayed her, you betrayed your fellow officers, you betrayed mightily the public trust all of us had.
Officer Fritz was ultimately sentenced to 1 year in county jail and 5 years of probation, yet he was not required to register as a sex offender. Melissa's family's reaction to the sentence spoke volumes about the injustice they felt.
You know, there's a family behind here, and unfair, you know, it's a year and 5 probation. It's not going to compare to what my mom has gone through, what our family has gone through, what we've lost in a year. We've bonded in a year, we've gotten closer, but I'm thankful that they took this seriously and that what needed to get done got done. It's out there, and he's not going to be a police officer anymore.
However, the case didn't end there. Melissa is now suing Officer Fritz and the city that employed him, seeking justice and the compensation she rightfully deserves. We can only hope that the lawsuit will finally hold those responsible accountable. Think a badge can shield a cop from accountability. Watch how this judge shuts the officer down for the inexplicable crime.
Mr. Bryant, you now have been convicted of 3 felonies.
Next up, we have a chilling case. Prosecutors say ex-police officer Bryant Kidd murdered 16-year-old Susana Morales, who vanished after a routine visit with friends at the Sterling Glen apartment complex. And here's the unsettling twist. This wasn't some random location. It was the exact same complex where Bryant lived. Now he is on trial for kidnapping and murder.
State of Georgia versus Miles Bryant. Indictment number 24B-00156-4, count 1, malice murder. We, the jury, found the defendant guilty. Count 2, felony murder. We, the jury, find the defendant guilty. Count 3, kidnapping. We, the jury, find the defendant guilty. 4, criminal attempt to commit rape. We, the jury, find the defendant not guilty. Count 5, false report of a crime. We, the jury, find the defendant guilty. Signed June 12th, 2024 by the foreperson, juror number 16. Okay. Was this your verdict in the jury room? Okay. Was it freely and voluntarily made by you? Is it still your verdict?
Yes, Your Honor.
According to the motion, Brian is accused of repeatedly invading people's privacy, with investigators pointing to 9 instances where intimate photos and videos were accessed without permission.
Anything else from the state or the defense this time?
Nothing on behalf of the state, Your Honor.
Okay. Mr. Bryant, you now have been convicted of 3 felonies. I want to inform you have a right to seek post-judgment relief from your felony convictions by either filing a direct appeal to a higher appellate court or to file a motion for a new trial. You have 30 days from the date I sign and file your sentence with the clerk of court to file a motion for new trial to any and all of the felony charges. You're going to file a motion for new trial?
Yes, ma'am, and I did discuss that with my client about that process.
Okay. You also have 4 years from the date of your sentence, from the date your sentence is final, to file a habeas corpus petition on the felonies. I'm going to appoint you an appellate lawyer to handle your case. Your trial lawyer is going to file a motion for a new trial within the 30 days to preserve your rights, and then your appellate attorney will explain these processes. but I want you to know the legal time frame that are required. You've also been convicted of a misdemeanor, and you have 1 year to file a habeas corpus on the misdemeanor of false report of a crime. I'm going to ask the jury to go back to the deliberation room and come back and talk to you, and then I'll be back out for sentencing.
Yes, ma'am.
When it came time for consequences, Judge Adkins made it permanent with a sentence of life in prison without parole for the murder and a consecutive 12-month sentence for filing a false report just to seal the deal. This cop thought he was untouchable, but the judge had other plans for him.
I am going to set a $250,000 personal recognizance bond in this matter with standard bond conditions.
On April 17th, 2024, in Kentwood, multiple agencies moved in on Samuel Sterling over outstanding felony warrants. Sterling took off running, triggering a pursuit that ended abruptly when an unmarked Michigan State Police vehicle driven by Officer Keely struck him. Sterling later died at the hospital the same day. Now, Officer Keely is on trial.
And I know that the bulk of you are here for the matter of the people of the state of Michigan versus Brian Keely. And I know that means that many of you have strong feelings and strong beliefs about this matter. With those come strong emotions. And so I'm asking you, if any of you experience those strong emotions and they lead you to feel at any time overwhelmed, I'm asking if any of you are experiencing strong feelings or emotions that overwhelm you, that you please excuse yourself from the courtroom. It is very important that we do maintain decorum. If you are unable to do so on your own, court security may assist you.
Initially, Kent County Prosecutor Chris Becker announced he would not pursue charges against Officer Keely, but that wasn't the end of the story. Michigan Attorney General Dana Nessel stepped in, overruled the silence, and filed the charges herself.
This time, the court is going to call people of the state of Michigan versus Brian William Keely, case 24-601-16FY. I understand Mr. Keely is in custody.
Mr. Keely's here with me.
Oh, he has been brought in already. Counsel, your appearance for the record.
Mark Curtis, honored to be here on behalf of Detective Sergeant Keely.
And you are Mr. Keely.
Yes, ma'am.
Welcome, Mr. Curtis. Welcome, Mr. Keely. You may be seated. Mr. Keely, in this matter, the people are alleging that on or around April 17th of 2024, in the city of Kentwood, County of Kent, State of Michigan, you committed the following offenses. Count 1, homicide, murder, second degree, upon one, Samuel DeJohn Cornelius Sterling, said act committed without premeditation or deliberation, contrary to MCL 750.317.
While Internal Affairs was still looking into it, Officer Keely quietly retired. And just like that, the department's authority vanished with the badge. No longer an employee, no discipline, no decertification.
That is a felony. It is punishable by life or any term of years. A consecutive sentence may be imposed for each death that resulted from operating a vehicle, and your DNA is taken upon arrest. Also allege count 2, homicide, manslaughter, involuntary, in that you did cause the death of Samuel DeJohn Cornelius Sterling by committing the following act or acts in a grossly negligent manner, to wit, the apprehension of Samuel DeJohn Cornelius Sterling, contrary to MCL 750.321. That is a felony. It is punishable by up to 15 years in the Department of Corrections and a fine of up to $7,500 with your DNA taken upon arrest, and a consecutive sentence may be imposed for each death that resulted from operating the vehicle. In these counts, felony in which a motor vehicle was used means a felony during the commission of which the individual convicted operated a motor vehicle, and while operating the vehicle presented a real or potential harm to individuals or property.
And when the judge asked for his plea, the ex-officer had the audacity to plead not guilty. After taking an innocent life, he's standing there, calm as ever, like nothing happened.
Do you understand those charges?
I do.
And do you feel as though you have had ample time to discuss your rights with Attorney Curtis?
I do.
Do you understand your rights?
I do.
Attorney Curtis, how is your client pleading at this time?
Not guilty to both charges, Your Honor.
The court will enter not guilty pleas in each of these counts, and we will schedule a probable cause conference and a preliminary examination. The purpose of those hearings is for the people to prove that there is probable cause to believe the felony offenses were committed and that you are the individual who committed them.
Seeing the details alone have everyone in the courtroom on the edge of their seats.
Attorney Curtis, would you like to make argument for bond?
In regards to bond, Your Honor, Mr. Detective Sergeant Keely turned himself in and has been cooperating with the investigation and also has been in contact with me almost on a daily basis. I have no concern that he is a flight risk. He is not. He's going to stand before the court and confront the charges. We're not concerned about him leaving the area. We're not concerned about him being a danger to the public, as in the fact that he was in the lawful performance of his duties at the time as a task force member. He isn't currently working as a trooper or Michigan State Police at this point, so there isn't any concern of him being in danger further to the public as to the operation. I would ask the court to consider all the facts and the fact that this is the first time one of the first times that he's been in legal trouble. He has an exemplary career as a trooper with the Michigan State Police. I'd ask the court to consider at least imposing a PR bond, and if the court is not considering a PR bond, to at least do a 10% extra surety bond to allow him to be able to cooperate with me in his defense. I think that him being incarcerated would limit our ability to prepare for preliminary examination in this matter.
The Michigan State Police let Keely retire instead of firing him. Clear proof the thin blue line looks out for its own. Meanwhile, his attorney went on and on, bragging about what a great officer he supposedly is.
And those were some of the questions that I had, Attorney Curtis. Does he have grievances in his record? What does his record look like? You're telling me that there are no prior instances of this nature in his history?
No, I've reviewed his personnel file, Your Honor. I've talked to the people that know him. There is no grievances in regards to excessive use of force at any other point in time, any motor vehicle accident. To this point, as a matter of fact, he received the gold reward from the Michigan State Police for having 12 years of accident-free at-fault accidents in operation of police vehicles. A man of faith attends church regularly, and he is not a person that I am concerned that is not going to appear or is a danger to anyone.
And how long has he been on the force?
He was a trooper for 25 years. He was 26 at the time that this happened.
And so the things that the court considers are risk to public safety, willingness to appear and stand trial, prior criminal record, and as it is Detective Sergeant Keely turned himself in willingly, does appear willing to appear and stand trial in this matter, has little to no criminal record, and certainly nothing that leads me to believe that there is a risk to public safety that is representative of the conduct alleged in this matter. I do agree that a personal recognizance bond is appropriate.
How does someone secure a personal recognizance bond on a murder charge? Remarkably, Keely did not have to pay a single cent to be released pending trial, a decision raising serious questions about the system.
I am going to set a $250,000 personal recognizance bond in this matter with standard bond conditions. I understand he is suspended from his duties at this time.
A little bit of limbo as to where he has filed for his retirement. The Michigan State Police have released to the media that he has retired from the department, but he was suspended without pay up until the Michigan State Police made that announcement to the media.
And so while this case is pending, you may not leave the state of Michigan. You must update your address with the court and then continue to keep it current with the court.
Defense attorney Curtis argued that Keely's MSP status was in limbo, hinting at complications with his role during the investigation.
Of course, commit any crimes while on bond, and you must show up on time for your court appearances, which are...
Keely, well, she's a good judge. That's the only thing I'm saying. You love her. She's a great judge. Great, amazing.
Security.
But you?
Security.
Thank you, ma'am. Anything further in this matter, counsel?
If I may, Your Honor, given the facts and circumstances of this case and the charge, in discussion with the AG's office, they were expecting me to ask the court if we could enter onto the record a 21-day waiver at this point. So if there is an adjournment down the road, we don't have to worry about putting that on the record at a later time.
And the bond court rules do require that the probable cause conference and preliminary examination be set within certain time guidelines, voluntarily waiving your right to have those hearings held within those specific time guidelines.
Yes, ma'am.
And then we will enter that waiver onto the record. Are you asking to have either or both of those moved at this time?
I think we can do the probable cause, Judge, and let me talk to the prosecution, and then we'll be able to determine whether or not we'll be able to go forward on that date.
All right, please let us know then on the 17th whether or not we need to adjourn the preliminary examination out any farther.
Will do, Your Honor.
All right, we're adjourned in this matter. Thank you.
Keely faces one count of second-degree murder, a life offense, or alternatively, involuntary manslaughter, a 15-year felony. The judge set a $250,000 personal recognizance bond, noting that the 26-year veteran trooper had no prior history of incidents. Well, that brings us to the end of this video. Today, we saw some of the most arrogant cops get called out and roasted by judges right in the courtroom. It's clear that no one, not even those in uniform, is above the law. These officers must learn that accountability is not optional and respect for the rules is non-negotiable. If you agree with me, please consider showing your support by liking this video and also make sure to subscribe to stay updated on future cases like these.